Precarpathian University.
Yeah, Precarpathian.
And respondent JSC Trust Me Bank, represented by the High School of Economics. Okay, so I think first we should introduce ourselves as the arbitral tribunal. And then maybe the parties can go ahead and also tell us whether you have decided on the procedure that you would like to follow. So, am I right?
Okay, my name is Stefanyk. I'm a lecturer of the Belarusian State University and coach for Russian team of this university from HSE. I also do work for one private company as a consultant.
My name is Igor Turanov. I came from Moscow where I'm practicing litigation, arbitration, and mediation as a solo practitioner. So I'm participating in different petitions, including JES, including pre-moot for VRS. So, and this will be very interesting since last time I came to Minsk was 5 or 6 years ago. So everybody's welcome, and I hope we will enjoy our discussion, arbitration, arguments of both parties, and good luck to you.
And my name is Uli Jensen. I'm a teaching and research assistant at the University of Cologne in Germany. I coach the Vasyl team in Cologne, and I'm also very much looking forward to this hearing. So maybe now for a claimant first.
Okay. So my name is Stefanyk. I'm representing the Precarpathian National University.
Do you happen to have business cards or anything where we can see your name? Because we have to write in here. Yeah, that would be very helpful.
I will write.
Thank you very much. And you'll be the first speaker for
No.
the second speaker. You'll be the first speaker.
I will be probably the third speaker.
Right, okay, but the second speaker on your motion. You have it?
Yeah.
Yeah, okay. Thank you very much.
You know. Okay, so we decided that respondent will be. My name is Emil Kudorovich, and I'm a representative of a team of Prikarpatskiy National University, and I will be speaking for procedure part.
Okay, thank you.
Okay, my name is Stefanyk. I'm a representative from High School of Economics, and I will present the respondent. So I'm my colleague.
My name is Artur Berez. I represent High School of Economics, and I will be responsible for the material.
Maybe we could do the same thing with
Yes.
the, sorry about that.
Yes, but it is not written correctly.
Okay, so how should I spell it?
Beryoza.
And you'll be the very first speaker then, starting.
But
So
there
we're
was
going across. Okay.
Yeah.
So we're starting with Anastasia. And then your first name is spelled correctly.
Yes.
And your second name should be
Beryoza.
Great. Thank you very much. Okay, so I understand every one of you is going to take 15 minutes for your regular presentation, and then will you reserve 5 minutes for rebuttal each? Is that how you want to allocate it?
Yes.
And do you want the rebuttals and sur-rebuttals right after the procedural part or in the very end?
At the very end, I think.
Maybe we take time for questions after each part of the, for example, after each procedure and part we can take, for example, 5 minutes of questions.
We were thinking, I don't know, the way I'm used to it is that we ask questions during your presentation unless you are uncomfortable with that.
I think it's really not very comfortable for us because, for example, we want to hear an answer and it will be interrupted for us. For example, it will be interrupted in our speech. It will be like a mess. It will be better to ask the questions after.
Are we going on the procedure as it goes? So
That was my impression.
Yeah, judges ask you questions during your speech. So we are able to interrupt you as much as we can.
But we will make sure that you have the 15 minutes. So tell us that if you feel that, so we're going to keep time. And after 15 minutes, we're going to let you know, okay, now your time has come to an end. But if you feel that you haven't been given enough time because we've been asking a lot of questions, let us know. Then just ask us, can I have please another 2 or 3 minutes? And then you'll probably be provided with those minutes. Okay, so we're first going to respond on procedure, then claimant on procedure, and should we have rebuttals then? Yeah, okay. And then we'll do the same thing for respondent, for substantive, but then claimant will start with substantive and respondent will answer. Is that correct?
Yes.
And then we have rebuttals afterwards.
Yeah.
Perfect. Okay. Any questions left from your side as regards procedure? Co-arbitrators?
That's phenomenal.
Okay, perfect. Then I would like to give the floor to respondent on procedure.
Okay. I will present the procedural part of respondent, and I want to divide my speech into 3 parts. First of all, we want to claim that we would like to ask the arbitrators to suspend the proceeding due to the fact that there is a parallel proceeding in another part of the other case. The second argument is that the arbitration clause is not incorporated in the letter of credit due to this fact. We understand that the respondent is not a party to this arbitration clause, and due to this fact, the arbitrators don't have jurisdiction on this case. And the third, it's that admitting by our claim that we admit ICC rules 2012, by admitting this, we don't claim that we admit the jurisdiction of arbitrators. So now I'm going to the first argument, and I want to say that. So, first of all, we need to notice that in this arbitration, the claimant purported to conceal the fact that the buyer has just initiated another procedure in other cut. So it's another arbitration procedure. For example, on 25th of March 2016, the buyer filed a request for arbitration against Lux Yao, and the claimant present his arguments in ICC case number 1998. So in this case, the buyer claims for admitting that the acceptance act shall be declared as invalid, and that it claims damages for defects of the yak that was produced by the Lux yak. And also it asked to make the payment, but he would like to make this payment like to make credit of this payment and to ask just $7 million of dollars. So we are aware of 2 principles of the best practice of international trade law. For example, also these principles named as lis penens and res judicata, and then introduced by International Law Association recommendation. And for example, these 2 principles has the purpose to preclude the multiplicity of procedures or dispute settlements. And for example, thus there is another procedure in another case, for example, that we already named, it's 1998. We need to claim that this case is on the same grounds with the same persons and brought by them and against them in the same capacity. So, if this case will be decided in favor, for example, of buyer, and for example, the act of acceptance will be declared as invalid, we consider that there will not be basis for current arbitration. So we understand that to effect effective and to provide effective case management, we understand that it will be relevant to suspend this arbitration until the other case, 1998, will be awarded, and when we until the time when we will understand what is the decision of this case. So, also, we would like to notice that there is some possibility also to claim such request, as I already have said. Also in the case when there is different parties and when there is a little bit different grounds. But it must be noticed that it can be done when three conditions are met. These conditions I want to name to you, and these conditions also is stipulated in the Article 6 of International Law Association of Recommendations of International Law Association. And there is stipulated that the arbitral tribunal, this is possible when the arbitral tribunal in the current arbitration is not precluded from doing so under the applicable law. Also, if it is satisfied that the outcome of other pending proceeding or settlement process is material to the outcome of the current arbitration, and satisfied that there will be no material prejudice to the party opposing the state. We want to claim that all these conditions are met in our case. For example, we need to stress that the fact that I already have noticed that if the act of acceptance will be admitted as invalid, will be recognized as invalid, it will influence the fact that our current situation will be unplaced. So we
Sorry, Council, may I interrupt you? You said that all the conditions are met in our case. Can you provide me, please, with the facts of the case and the conditions directly?
about which one of conditions?
Every condition.
Every condition. Okay.
All conditions.
For example, we say that there is a condition that the arbitral tribunal in this current arbitration is not precluded for doing this, so under the applicable law. We don't have the evidence that there is some causes that preclude, for example, current arbitration from them deciding this case, and under the applicable law, it is prohibited. We don't have the evidence in the material case, and it is not provided some facts that can be considered as the case influence the right of arbitration and the possibility of arbitration to do this. The second is that the outcome of the other pending proceedings will be major, or will have major importance. I already said it that, for example, if the act of acceptance will be recognized as invalid, it will be obvious from our side that there is no base for considering the current arbitration. And the next is that that there will be no material prejudice to party opposing the state. We think that if the case, another case, will have such kind of decision, like for example in the favor of buyer, we think that it will break, I don't know, or for example have some prejudice for the right in this arbitration. Okay, so the next part and the next argument that I want to present is the fact that the claimant states that the arbitration clause that is incorporated in the shipbuilding contract is also extended to us, to respondent. So we need to state that it is from our side. It is not verified and it's not proved by the claimant. We base our consideration on the fact that, first of all, due to the UCP 600, there is an Article 4 that provides that the letter of credit is an independent document. And so we need to say that if it is an independent document, it has power just to the parties that party to the letter of credit. But we need to say that, for example, respondent, we are not a party to the shipbuilding contract. We can't say that if we are not a party to this shipbuilding contract, we are a party to arbitration clause. So, for example, in Article 10 of letter of credit, there is, I can read it, for example, to make evidence. So this letter of credit is issued without prejudice to the shipbuilding contract number 765 of 23rd of February 2015, which shall have a full effect with regard to the terms of the letter of credit. Okay, so here we see that it's issued without prejudice, so we can say that it is independent from the shipbuilding contract. Also, we need to notice that, for example, we didn't make some, for example, the arbitration agreement can be made by the arbitration clause and also by the separate arbitration agreement. We need to notice, and there is no some evidence in the materials of the case that we had some agreement with the claimant on this subject. So we didn't enter in some arbitration agreement. Also, we didn't see that in the letter of credit there is some kind of arbitration clause. We can't say that because also we need to say that this reference to the shipbuilding contract in Article 10 that I already read, it was just a reference to state that the letter of credit is independent from the shipbuilding contract, but not to say that this reference like a kind of arbitration agreement.
No, Sir Counsel, do you understand that you're right that there is no arbitration agreement between the parties?
Between the claimant and respondent, no, there is no arbitration.
So you state that we shouldn't be sitting here right now and shouldn't be listening to you?
Yes, you're right.
And who would be competent to hear the dispute then?
We think it will be, for example, we understand that it will be relevant to suspend these proceedings until the decision will be awarded in other case that are already named 1998 between the claimant and the buyer, because there is another case that has a very major importance for our case. And we think that if we take, for example, if we continue this arbitration proceedings, if we continue this pleading of parties, we understand that it can influence the effectiveness of case management. I can.
Counsel, if we waited for that arbitration to finish, would we then be competent, or would you still say we're not competent?
I think that we need to, maybe we will be, we can discuss this, or for example, parties are capable to make also another arbitration agreement because there is no arbitration agreement. Also, we can do it
You
after.
would be willing to make an arbitration agreement with the claimant if we suspend the proceedings until the 1988 proceedings are concluded?
Maybe we can, for example, make some agreement and we decided to change the arbitrators. I think that we will be able to do this.
But you would want to change the arbitrators?
No, I don't say that I want to change arbitrators that we now see here. I say that if we will have some wish, for example, to move our dispute settlement in other, for example, country or in other place, maybe we need to do this. Now I can't discuss this position because we need to wait for the award from the other case. Also, the last argument that I want to state is that by claiming that we accept the ICC rules 2012, by admitting these rules, we don't admit the jurisdiction because it can be provided by the claimant that by admitting these rules, we admit the jurisdiction of the arbitration. We need to make a presumption that we don't do this.
I do have a question. What was wrong with initiating two proceedings in parallel? So, because here we are talking about letter of credit and documents to be presented to the bank. In another case, other parties, they're just arbitrating the issue of quality of the good, maybe some damages to be covered. So, in any situation, it is possible that probably some settle from accounting side could be needed.
And we understand that, for example, the validity of actus successors also is a subject of the other case, of the other dispute resolution. So we understand if it will be in favor of buyer, we understand that it will not be, this arbitration proceeding will be unbased. And we understand, for example, if we continue our arbitration, and for example, this arbitration will be in favor of the claimant, and another arbitration, unfortunately or unfortunately, will be in favor of the buyer. We have two contrary case decisions. It will be, I think, due to the best practices of international trade, and also, for example, to the ICC rules. I think it will be effective to make the decision in line with it, not in contrary.
And so, in very short words, so what do you propose to change arbitrators, to suspend, to wait, to challenge jurisdiction of the arbitral tribunal?
Now our request is to suspend the arbitration proceedings until the other case will be decided by the arbitrators.
And,
So that
and then the issue of jurisdiction will be resolved.
I think yes. Now we don't have some agreement with the claimant on the other arbitrators. So now we just ask to suspend, and then maybe
Okay, but tomorrow an arbitration award will be rendered, and what will be change with working letter of credit?
it will depends of the decision of the other case. I think because after the decision we can, I suppose so, we can came to some conclusion and we decide if we admit that the letter of credit also can be, that case with the letter of credit also can be decided with the same panel of arbitrators, or we need to make another agreement because we don't admit it, and so we need to, for example, select another place, another arbitrators or something like this.
But by admitting to the arbitration of ICC arbitration rules, maybe you don't have such flexibility because since you admitted, the competent authority will be deciding who will be appointed for a particular case. And in many situations, arbitrators who have rendered a particular arbitration award, to some extent, they might be considered as maybe not biased, but probably some independent other people which are not independent and which are not bound by any decision of previous arbitral tribunals would decide more.
Yes, maybe we can assume it, but now we don't have a conclusion with the claimant on this part, and so we need to, I think we need to make an agreement because we didn't make it and we didn't have it in the letter ready. So now we just ask to suspend, and then I think we will decide what we can do after the decision of the other case.
Well, very flexible and pragmatic approach.
Thank you very much for your presentation. Any other questions from my co-panelists? Then I would like to move over to claimant.
Dear arbitrators, I have the greatest honor to appear on behalf of Vasyl's company Ltd as claimant in today's proceedings. And within the scope of today's claim, it will be shown that firstly, arbitral tribunal has a full jurisdiction to consider a case, and secondly, there is no need for suspension of the provision, and it's not applicable in this case. With your permission, I will start with the first issue that arbitral tribunal has jurisdiction on this case. The claimant considers that the respondent is the non-signatory third party to the shipbuilding contract, and it is bound by the arbitration clause in the shipbuilding contract. The way how it is bound is the incorporation of arbitration clause into the letter of credit. It strictly shows, the letter of credit strictly shows us such incorporation at Article 10.
Can you provide us to the...
Can you provide us with the page?
Page 22.
Yeah, page 22. It shows that this letter of credit is issued without prejudice to the shipbuilding contract, which shall have a full effect with regard to the terms of this letter of credit. So, Article 10 of the letter of credit sends us to the shipbuilding contract which contains an arbitration clause in Article 10(1)(2), which is like all disputes between the parties will be resolved by ICC arbitration. Thus, the claimant submits that the respondent is bound by the arbitration clause in the shipbuilding contract, and the arbitral tribunal has a full jurisdiction for considering this case. Claimant agrees that there is no specific reference to the arbitration clause in the shipbuilding contract, but however, the general reference in this particular case should be binding for the third parties.
So would you say that respondent has assumed all obligations under the shipbuilding contract?
Yes.
So respondent would also be obliged to deliver a ship?
No. He says that shipbuilding contract shall have a full effect on the letter of credit. So he agrees with all terms of the letter of credit, and it should be issued without prejudice to the letter of credit. And the claimant agrees that there is no specific reference only to the arbitration clause, but there is a general reference to the shipbuilding contract. And
would you agree, counsel, that having to go to arbitration instead of to a state court is an obligation for the parties?
well, when the parties agreed to arbitrate in the arbitration procedure, it's an obligation because there is an arbitration clause in the contract. So the parties, it's agreement with the parties to arbitrate. Why the claimant, so I will return to my point. Why the claimant agrees that a general reference should be binding for the third party, because the respondent against whom the arbitration was considered and had knowledge about this arbitration clause and accepted it tacitly. How? It has been aware of the arbitration clause and has kept silence, and we can use a principle here, contra preferendum. The bank is responsible for what he wrote in the letter of credit, because he independently created the letter of credit, the scope of the letter of credit, and in this way he accepted the arbitration clause in the shipbuilding contract. And when bank says that he didn't accept it and he didn't recognize the arbitration, that he didn't know about the existence of arbitration clause in the shipbuilding contract, in the same way the bank is saying us that he is not competent and he didn't read the shipbuilding contract, but nevertheless he included Article 10 into the letter of credit, which means that there is incorporation.
And sorry, counsel, you provide us with a factual basis, but can you provide us with a legal basis? Can you provide us with an example in the cases where we had the same situation?
Okay, so for example, in Comparator, the Court of Appeal Paris maintained that the arbitration clause incorporated by reference into the contract is valid if the party has been aware of it and kept silence. Swiss federal tribunals stated in the case Compagnie de Navigation et Transportes against Mediterranean Shipping Company that certain behavior of the parties, according to the rules of good faith, that infers that the third party has been aware of incorporation.
Thank you, counsel.
So, as I submitted before, the respondent all the time was aware of the existence of the arbitration clause in the contract, and the respondent was able to check the existence of arbitration clause in the contract too. And the respondent is responsible for what he wrote in the letter of credit, and the second, and I will point to the second example, that decision Court of Appeal of Paris held the provision that a non-signatory has been directly involved in the negotiation or performance or termination of contract containing an arbitration clause is ipso facto a party for this arbitration clause. As a respondent purchased a guarantee for the shipbuilding contract, letter of credit, and by doing such act, it already involved into the shipbuilding contract, and because it covers the same case. And it is proved by ICC case 5721. An arbitral tribunal says that abstract nature of the guarantee doesn't negate the fact that it comes from the underlying obligation and has a close connection to it. As I said, that letter of credit has a close connection to the shipbuilding contract, and it comes from the shipbuilding contract as a guarantee of the shipbuilding contract. So summarizing the first claim, all disputes regarding to the letter of credit should be settled in the arbitration procedure.
One question, counsel. I understood the case law and I see that it's somewhat on point, but do you have a case where specifically a letter of credit incorporated the arbitration agreement out of the main contract?
No, sorry, regarding I don't have this case, but I have similar cases that I consider it's related.
Yeah, I understood that. Thank you.
Now we want to move to my second point, that the arbitration should not be suspended. In the present case, the arguments of the respondent can be